Now, joining us on the program right now, very pleased to welcome to the show Mr. Steve Holbrook, Second Amendment attorney and scholar. Steve, thank you, sir, for joining us tonight.
My pleasure as always, Cam.
The blog, SCOTUS blog, had a post today. Lyle Dennison was writing about this. Less protection for gun rights. And he says, asked by the Supreme Court for its views on the scope of a constitutional right to have a gun outside one's home, the Obama administration has tentatively suggested a standard that would mean more restrictions on that right would probably be upheld in court. What's Lyle Dennison talking about here, Steve?
Well, that's actually an understatement. According to the Obama administration, there's really not much of anything that's going to violate the right other than a ban on handguns in the home, and that could change if he could get another Supreme Court justice in there. But it's in relation to the Maciandero case, and that's the case where a gentleman was convicted of having a loaded firearm in his vehicle on park land in Northern Virginia. And what's ironic about the case is that Congress passed a repeal of that, and Obama signed it, so that it's no longer prohibited to have a loaded firearm in your vehicle. The key now is that you go by state law, and in Virginia, if you have a concealed weapon permit, it would be legal, or if it's not accessible, it would not be carried about the person, and therefore it would not even come under the concealed weapon law. So they use that as a reason to argue against the court taking the case because the regulation no longer exists. But then their next argument is that this is such a sensitive place, you can't allow guns there. So this is very strange. The regulations repealed, but it used to be a sensitive place, and we want to still convict this guy, even though there's no merit to prosecute him anymore.
Right.
What kind of prosecutor would want to continue a prosecution when the law evaporates under its feet? It's just to rack up his batting average. So,
well, yeah, and is there anything, I mean, at some point, there's got to be somebody within the administration that could say, drop the case, it's not a crime anymore, right?
Right. Yeah, but they say the law does not apply retroactively, so anybody that can still sweep under the rug and convict of a crime because they committed the act before the regulation came off the books, let's give them a criminal record. We love it.
Wow.
Well, here's another interesting thing. They say, oh, well, the Fourth Circuit didn't say the Second Amendment doesn't apply outside the home. They better read that case again. The Fourth Circuit said, two judges rather, said that Heller and McDonald said the Second Amendment only applies in the home, and we're not going to extend it any further. In fact, they quoted that Williams case out of Maryland that I was handling, doing a cert petition that they just denied, which said we're not going to recognize this right. And if the Supreme Court wants to recognize it, they're going to have to do it themselves.
Oh, really? So is this something that, Steve, the Supreme Court ultimately is going to have to take up at some point?
Well, they don't have to do anything they want to do. I mean, whether they're going to take this case, I don't know. I can tell you there's massive resistance throughout the country among the courts to recognizing what Heller and McDonald hold, not only about handguns in the home. You look at the long analysis Heller did on what bearing arms meant, and it meant carrying arms for defensive or offensive purposes. So, whether they're willing to take a case like this or not now, I don't know. But they sure got it wrong, and they make other arguments. I got to share this with you. They say, well, this is not a general issue throughout the United States because there's only two jurisdictions that ban all carrying of arms, and that's D.C. and Illinois. There's only two states that have no way to carry a handgun legally at all through a license or a permit or anything.
Right.
And, of course, what's at issue here is not those general laws, but whether this individual had a Second Amendment right to be in this parking lot of what's hardly a park. I mean, if you go up there, it's on the way to National Airport in Alexandria, Virginia, and it's the GW Parkway, and it's a parking lot right off of that, and there's just cars going by, and they act like, oh, there's children playing everywhere, and it's really not the case. They also argue that there's no need to scrutinize strictly any issue here, that if the right does exist, this so-called intermediate scrutiny, in which the government always wins, would apply. And then they have one last-ditch argument. They say, well, this is under the property clause that the Constitution gives the Congress power to regulate its property. But if you think about it, what do they have, millions of acres, or at least hundreds of thousands of acres of parkland, a lot of wilderness land? And you're telling me no Bill of Rights provisions apply in those places? They can regulate and ban any application of the Bill of Rights if void where prohibited by law?
Yeah.
Federal land, not just buildings we're talking about. We're talking about lands and parking lots and roads.
Well, and getting back to the what you said earlier about intermediate scrutiny, you said that means the government always wins. The levels of scrutiny that we're talking about here, strict scrutiny, right? And that is the toughest level of scrutiny. That's the and what does that actually mean legally, Steve? You're the one with the Juris Doctorate, not me.
Well, you have to have a compelling state interest to have the law in question, and it's been mostly applied to First Amendment cases. But as far as the fundamental right goes, it should be applicable to the Second Amendment as well, particularly regarding the core Second Amendment right, the right to possess guns at all, the right to carry them with certain restrictions, albeit, but still, it refers to the right to keep and bear arms. And what the framers had in mind was self-defense, military use, and hunting. And all three of those are things that take place outside the home. It's pretty rare you get to go hunting in your home, or I've never heard of militia exercises in your home. Self-defense can be anywhere. This intermediate scrutiny means they say, well, there's got to be a really, 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 really important government purpose.
Okay.
And so when they say that, look out. You have a right to keep and bear arms for self-defense, for one thing. Now, what's the government purpose that's so important here that in this parking lot by a road that you can ban guns? I mean, there's no really important government purpose there. If you want to ban them in a government child care center or something like that, that's another issue.
Mm-hmm. All right. Well, Steve, I know, again, I mean, this is clearly a live issue before the courts right now. And as you say, it's not just the Supreme Court that we need to be paying attention to. I mean, what these lower courts are doing is really troubling. I think your colleague Dave Kopel has a piece in America's First Freedom this month talking about the hollow or asking the question, I guess, was Heller a hollow victory? Based on what we're seeing now from a lot of these lower court decisions, many of these judges, it seems like they just don't even want to read the Heller or McDonald decisions.
Right. There's one footnote where the court talked about the long-standing regulations that are not going to be that will be presumptively valid. That means that there's a presumption you can rebut it possibly. That would be felon possession, mental incompetence. It also mentions commercial regulations, like having an SFL, things like that, or sensitive places, government buildings or schools, those sorts of things. But the court that's only like about 2 or 3 sentences, but the court went on and on and on, paragraph after paragraph, about the meaning of bear arms. And that's what the lower courts are all ignoring. There's no right to bear arms. I mean, what are you going to do, just cross it out? And so, these cases are coming all over the country. I think we'll know in a few weeks whether they're going to grant review in this case, the Maxine Nero case. They just denied cert in the Williams case that I brought. There'll be other people knocking at the door, and we'll see what happens. I mean, they could take a case, or they could just ignore the issue for a long time. The tea leaves, reading the tea leaves for the Supreme Court, I gave up a long time ago on that.
All right. Well, listen, Mr. Holbrook, again, real pleasure having you on the show tonight, sir, and hope to do this again very soon.
My pleasure, Ken. Thanks for having me.
You bet. Steve Holbrook, Second Amendment attorney and scholar, joining us here on Cam and Company.